A very warm welcome to this webinar in the seminar series SNS Sustainability Talks. This time we will focus on business and human rights and the role of the UN guiding principles. In 2005, the UN Secretary General Kofi Annan appointed Professor John Ruggie as the UN Secretary General's Special Representative of Human Rights and Business and Human Rights, and with the task of proposing measures to strengthen the human rights performance of the global business sector. In June 2011, 6 years later, the Human Rights Council endorsed the guiding principles on business and human rights that Professor Ruggie and his team developed during 6 years of extensive consultations, pilot projects, and research in different areas. And this was the first time the UN had issued official guidance to states and firms of their respective duties and responsibilities in relation to business and human rights. And the expectations set out in the principles are now informing the development of national and supranational international law, hard law, and requirements in a growing number of jurisdictions. Last year in September, we received a very sad news about the passing of Professor John Ruggie. Citing Jane Nelson, the director of Kennedy School's Social Responsibility Initiative that John Ruggie led, she said, he combined a superb intellect and strong principles with great kindness and compassion, and a deep commitment to achieving practical progress in global efforts to respect human rights. In his task, developing the guidelines and the guiding principles, John Ruggie worked together with a small team. And it's a great honor to welcome Caroline Rees, a lead advisor to Professor Ruggie during his term as special representative. In that role, Caroline was deeply involved in the extensive consultation and also in drafting the guiding principles. And today, Caroline will talk about how the UN guiding principles have informed the development of new legislation or regulations, shaped investors' analysis of companies' social performance, and also about how business are embedding the guiding principle in their operations and in their value chains. I will also welcome later on Cecilia Ekholm, Minister for Foreign Affairs, and Théo Jaekel, Ericsson. Both of you will get a proper introduction when we start up our panel discussion. And my name is Mia Rantzien, and I'm the CEO of SNS. Before we start, as always at SNS, we want the audience to take part in the discussion. You can use the Q&A function on your screen, and we hope you to be active. So let me now welcome Caroline into the screen. You are the president and co-founder of SHIFT, the leading center of expertise on the UN guiding principles. And before becoming the lead advisor to John Ruggie on business and human rights and the process in 2007, you spent 14 years in the British Foreign and Commonwealth Office with a service career which covered Iran, Slovakia, UN Security Council in New York, and the European Union in Brussels. And from 2003 and 2006 to 2006, you led the UK's human rights negotiating team at the UN and ran the negotiation to establish the mandate for John Ruggie. And from 2009 to 2011, you were also the director of the Governance and Accountability Program at the Corporate Social Responsibility Initiative at Harvard Kennedy School. And you remain a senior program fellow there. The list of your advisory function in a number of different boards is also long. So we're very happy to welcome you back here at SNS. And the screen is yours. Please, Caroline.
Mia, thank you so very much. It's a real pleasure to be with you all today, and I'm looking forward to hearing from Théo and Cecilia as well and being part of the conversation that follows. Mia, as you said, we suffered a sad loss in September when John Ruggie passed away, and you cited Jane's words that spoke not only to his extraordinary career, but also just to who he was as a person, someone of tremendous humility and humanity, as well as mischievous good humour. I've been struck in the various tributes to John by how both the academic giants who knew John's incredible contribution to the field of international relations actually knew relatively little about his work in the world of international policy and standards. And on the other side, many people who have been very much aware of his achievements, from the Millennium Development Goals and the Global Compact through to the UN Guiding Principles, are only faintly aware of his academic standing and his singular contributions in that sphere. And I raise this today because it matters. The drafting of the Guiding Principles was not just an exercise in working out a current day consensus around practical propositions for what states, businesses, and others ought to do when it comes to the risks to people that can flow from business practice. The Guiding Principles actually have long and deep roots in John's academic thought, based on decades-long research and observations of forms of global governance, the nature of norm development, rulemaking, and so forth in the international arena. And that really goes to the fact that they aren't just a transient text that's soon to be overtaken or made obsolete by developing events. I really see them much more as a kind of a constitutional document that provides orientation and insights into how to approach those very developments. They speak directly to today's pressing issues of human rights risks facing the tech industry, for example, of business action in the face of state-sponsored forced labor, of the relevance of respect for human rights to achieving the SDGs, to name just a few examples. So I'd like to dwell for a moment on those deeper roots of the Guiding Principles with a couple of quotes from John. The first is from his report to the UN in 2008. That was the end of his first 3-year term as the Secretary General Special Representative. And it was in that report that he presented the so-called Protect, Respect and Remedy framework, which he was then, of course, asked to go on and operationalize in his second term, which led to the Guiding Principles. So in that 2008 report, John wrote, and I quote, "The root cause of the business and human rights predicament today lies in the governance gaps created by globalization between the scope and impact of economic forces and actors and the capacity of societies to manage their adverse consequences. These governance gaps provide the permissive environment for wrongful acts by companies of all kinds without adequate sanctioning or reparation. How to narrow and ultimately bridge the gaps in relation to human rights is our fundamental challenge." Unquote. So we see the diagnostic insight that the lens of business and human rights is bringing, and it comes through further when John refers in the same report to the fact that, quote, "escalating charges of corporate-related human rights abuses are the canary in the coal mine, signaling that all is not well." Unquote. Fast forward then to December 2019, and John was then speaking at a conference on business and human rights organized by the Finnish presidency of the EU. And he observed the following in that context. He said, "What is business and human rights all about? In big picture terms, it is about the social sustainability of globalization. Some years ago, my favorite boss, Kofi Annan, said, if we cannot make globalization work for all, in the end, it will work for none. Today, people around the world are telling us that we have fallen short, that the benefits and burdens of globalization have been unequally distributed within and among nations. The result is public resentment and loss of trust in institutions of all kinds." So in sum, we have at once a diagnosis and a prescription that goes to the heart of why business and human rights is so relevant to today's world. It speaks to the human dimensions of sustainability, what undermines the resilience and cohesion of societies and what's needed to support and strengthen them. It speaks to the harsh reality of today's inequalities and the system level risk that these pose to societies and, of course, to business itself. And it speaks to the new momentum around the idea of a stakeholder capitalism that rebalances the overweighting of shareholders' interests and the increasingly false proposition that those interests are uniquely financial. John went on in the 2019 conference to observe the following. He said, the UNGPs are not merely a text. They were intended to help generate a new regulatory dynamic, one in which public and private governance systems, corporate as well as civil, each come to add distinct value, compensate for one another's weaknesses, and play mutually reinforcing roles, out of which a more comprehensive and effective global regime might evolve. So that regulatory dynamic that John was talking about there is exactly what we're now seeing really take off, particularly in the European arena. And you alluded, Mia, to this in your opening notes. So let me perhaps turn now to focus on those developments, developments for which this year is going to prove particularly important. And I'll try to paint a bit of a picture of the evolution we have been seeing. To start with, this regulatory dynamic that John spoke of is not a phenomenon, of course, of just the last year or two. It began in developments related to sustainability reporting quite soon after the endorsement of the guiding principles. The first such developments typically focused on human rights risks around forced labor, child labor, slavery, trafficking, and in relation generally to corporate supply chains, where questions of their financial materiality to shareholders was honestly seen as moot. We saw this develop first with the California Transparency in Supply Chains Act that came into force in January 2012, about 6 months after the adoption of the guiding principles. It continued with the Modern Slavery Acts in the UK in 2015, in Australia in 2018. And for a period around the same time in the US, there were reporting requirements on due diligence for companies investing in Myanmar, just as sanctions were being lifted there. In 2014, we saw the much broader reporting requirements come through in the context of the EU, as many will know, with the Nonfinancial Reporting Directive. And this required reporting by large public interest companies with more than 500 employees on environmental matters, social matters and the treatment of employees, respect for human rights, anti-corruption and diversity. While no specific disclosures were mandated there, it left it quite wide scope for national governments on how they implement them. It was stated in the directive that companies can rely on international frameworks such as the guiding principles. And already the idea of so-called double materiality was present, meaning that reporting should cover both companies' significant impacts on people and planet, as well as sustainability-related risks or opportunities for the business. And meanwhile, outside of the European and Anglo-American arenas, we were seeing the adoption of non-financial reporting requirements in some other jurisdictions, including on human rights, such as in South Africa and in India, in relation to listed companies. And now, fast forward 2022, of course, that 2014 directive is expected to be replaced by the Corporate Sustainability Reporting Directive later this year, which is currently going through the European legislative process. This will create the basis for a European sustainability reporting standards body to develop a range of mandatory disclosures across environmental, social, and governance areas, and also on the basis of double materiality. With investors already being required now to start reporting certain sustainability information on their portfolios, that's part of the Sustainable Finance Disclosure Regulation, there's been pressure for these new standards for companies to be developed quickly, since investors need the very companies they invest in to provide the information that will feed their own reporting. And so it's with this in mind that an interim process to begin drafting a first set of reporting standards has been underway since last summer. I'm happy to say more about that in discussion. And this work will be handed over to the new formal bodies that are in the process of being constituted in Q2 of this year. At the same time, there's considerable attention to, and even I would suggest concern about, how these European sustainability reporting standards based on double materiality will relate to the standards that are now due to be developed by the International Sustainability Standards Board that was launched at COP26 in November of last year. Following the initial approval of a climate reporting standard, the ISSB is expected to progress to wider environmental and social issues. And in the social arena, it will seemingly start with diversity and inclusion, but of course with a focus there on financial materiality alone. There's a lot of uncertainty as to how narrowly or broadly it will understand the category of social issues and their materiality for business. Ideally, the vision is that the ISSB standards should create some building blocks, a sort of global foundation, if you will, to which EU standards can then add further granularity, the additional lens of impact materiality. But much, quite honestly, remains to be seen in practice as to whether this kind of complementarity and coherence can be achieved. The new EU reporting standards should certainly reduce the huge variation in both the quantity and quality of sustainability reporting by companies in the European arena today. However, this very variation itself and the resulting sparse evidence that reporting standards have been driving improved social performance have contributed to the growth in calls for mandatory human rights due diligence. And that is, of course, moving beyond regulation on the reporting of conduct to regulating conduct itself. We saw this trend, this move first in the French duty of vigilance law adopted in 2017, the first to apply comprehensive human rights and environmental due diligence obligations to companies, attaching some consequences there for a failure to meet them. And in 2019, the Netherlands adopted a law that required companies to conduct due diligence with respect to child labour and report on that, again with sanctions for non-compliance. Last year, as many will know, Germany adopted its supply chain due diligence law. That requires companies it covers to conduct human rights due diligence focused on their own activities and direct suppliers, and to respond to substantiated concerns about impacts deeper in their supply chains. Norway adopted its transparency law, a different approach taken there, but that requires companies to carry out human rights due diligence, report publicly on the results, and respond to questions put to them by stakeholders. And the Dutch government has announced that it'll move to replace its child labour specific law with comprehensive due diligence legislation, which will include both civil liability and regulatory oversight. The Finnish government is due to release its proposal for national legislation any day, and there appear to be legislative plans afoot in Spain as well. So we can see that gathering of momentum. Meanwhile, in the United States, we've seen a distinct approach where the Customs and Border Patrol are empowered to withhold imported goods that are suspected of being produced with forced labour. And under that model, it's up to importing companies to demonstrate, including through human rights due diligence, either that the goods are not tainted with forced labour or that any impacts have been remediated. Canada has begun exercising similar customs powers, and the president of the European Commission has called for similar measures to be adopted at EU level. All of which brings us to today, when we are indeed awaiting a long anticipated draft proposal from the European Commission for mandatory human rights and environmental due diligence as part of its Sustainable Corporate Governance initiative. Indeed, as we heard, the date for release of the proposal is supposedly tomorrow, the 23rd of February. And despite prior postponements, it does indeed look as if it will be forthcoming. Like many others, we at Shift will be scrutinising that proposal carefully for its alignment with the guiding principles and sharing some analysis publicly. It has been long awaited and will get a lot of scrutiny, I'm sure. I think very importantly at this stage in the regulatory evolution, we are seeing growing numbers of companies and business groups coming out in favour of such regulation of human rights and environmental due diligence. And I'm really delighted we'll be hearing from Théo later, Ericsson having taken a positive and really thoughtful stance on this issue itself, along with some other companies. And I think the readiness of companies to do so reflects a recognition that actually such legislation could bring a number of benefits to business itself. It should create a level playing field by holding, let's say, the slower companies to act to the same standards that the leaders have now been applying for some time. It should provide companies with more leverage with their business partners on human rights issues, so helping them to better reduce risks to people across their value chains. And by being positioned at the EU level, it should increase legal certainties for many businesses, not just EU headquartered businesses that are affected by that legislation, by creating a harmonized approach. We've seen groups such as Amfori, the Sustainability Focused Trade Association, the Responsible Business Alliance, which focuses on electronics and supply chains, the European Brands Association, AIM, all of these organizations bringing their voices into this constructive debate. And while many of these companies and associations remain cautious about the specifics of legislative proposals, they have demonstrated their commitment to a discussion about not whether, but what. Of course, it isn't true of all business groups, but it is worth adding that the general positive momentum was reinforced last year by an investor statement from investors with over $5 trillion in assets under management, calling on governments to institute mandatory human rights due diligence. The fact is that there's now a real and useful conversation underway, one that is capable of nuance and even sophistication. And indeed, that conversation and the legislative process it will accompany is perhaps the most critical opportunity we now have before us. It's one that was anticipated in the guiding principles, which call for a smart mix of measures, mandatory as well as voluntary, international and national, in order to achieve the ultimate goal of respect for human rights. It's one where we must be able to discuss the role of civil liability, which was itself foreseen in the guiding principles as well and is rightly expected to be part of the EU proposals. Appropriate civil liability is a necessary part of providing accountability and of enabling remedy to people who are harmed. But at the same time, it's not the full answer, given the limited set of business relationships to which liability is likely to apply. So that's going to mean member states needing to have in place administrative supervision and regulatory agencies that are equipped to assess the seriousness with which companies are pursuing due diligence across the full scope of their value chains. However, there is nothing preordained to say that legislation will necessarily succeed in its aims. To do so, it must be carefully drafted with an understanding of what it takes to shape better practices that deliver actually improved outcomes for workers, communities, and consumers. If it leads only to minimalist tick box compliance, it will actually fail. And that's in large part because respect for human rights is first and foremost about mindsets, behaviors, and culture. Culture that demands direct engagement by company leaders and boards, engaging with affected stakeholders to gain insight into their perspectives and experience, and providing oversight of how risks to people and planet are identified and addressed. Moreover, legislation isn't itself a silver bullet. It needs to sit alongside other drivers of corporate practice, and that includes roles played by financial institutions and markets, as well as civil society. And those need to support the clarity and the coherence that companies sorely need and are frankly quite right to demand. And that needs to start with the EU itself, ensuring that both the reporting standards and the due diligence requirements it develops, even though they're being developed through separate and parallel processes, are themselves aligned with the guiding principles and support the same expectations of business. It means clarity around what good looks like, so that we can move beyond simplistic observations of whether certain company policies are in place or whether processes are name-checked in reports. We need to get beyond that and to a widely shared understanding of how business practices must adapt to avoid externalizing risks and costs onto stakeholders. And we also need to see wider market incentives that support the same direction of travel and really reward companies that are making positive strides without making naive demands of perfection, because that is not the world anyone operates within. So that is the opportunity that I would suggest we have today as we consider the forthcoming regulatory developments in the EU context. It really is an opportunity for thoughtful leadership on the part of all, leadership that reflects the very insights that underpin John's vision for the guiding principles, that we need to bring together, and I'll return here to his words, public and private governance systems, corporate as well as civil, to add their distinct value, compensate for one another's weaknesses, and play mutually reinforcing roles, out of which a more comprehensive and effective global regime might evolve. The prize, in closing, I would suggest, is great indeed. A world in which business routinely gets done with respect for the dignity and equality of all is a world that becomes ever more socially sustainable. It's a world in which inequalities of all kinds are substantially reduced. And it's a world where stakeholder capitalism moves beyond rhetoric and good intentions to gain real life in shaping our economies to be fairer and more just. And that is, simply put, what business and human rights is all about. Thank you very much.
Thank you so much, Caroline, for this very interesting and rich and important overview over both the thinking and also what is happening on this area. I wanted to, just before we go on to the panel discussion, ask you one question. You mentioned the need for clarity, coherence when it comes to standard, but also a common understanding of this issue of socially sustainable globalization. We do see a significant interest also in investors' interest in the S, in the ESG grouping, which relates to environment, social, and governance issues. So this interest in social aspects of company sustainability performance, we also see competing approaches of what it is, and sometimes an insufficient clarity of what the S means. What should be measured and how? And I would like to ask you, who've been in this process for so long time, how do you see this evolution? Are we heading in the right direction, or are we getting more proliferation and confusion?
Yes, thank you, Mia, and that's quite right. I mean, alongside the sustainability conversation, the inequalities conversation, the stakeholder capitalism conversation that I referred to, we've got this S in ESG conversation that's happening, which is really coming to so many of the same questions and issues. 2 points, I think. One is that we need a clearer architecture for what the S is about. And we need, secondly, better ways of measuring and evaluating who's getting it right. On the architecture point, I think what we've long seen in the S in the middle of ESG is that it's a bit of a grey zone of issues that overlap and are quite differently framed. We often see individual human rights related issues pulled out, like forced labour, health and safety, privacy. Then we'll see a function like supply chain management, or a category like communities, and then human rights can often appear in its own terms without reference to what else is there. And honestly, I think no company or no person can readily get their head around such a jumble of issues. So I think first of all, we need to start with a clear sort of mental model for this, that it is about people, individuals, groups, society, and how companies address impacts on those people and the risks that flow for business from that as well. We see that move towards the language of people as against just social in, for instance, the Global Reporting Initiative's new universal standards, which is very, very helpful. And when we talk about people, we can think about the workforce, we can think about value chain workers, we can think about communities, and we think about consumers and end users. So 4 clear categories of stakeholders, if you will, that can be impacted by business. And I think there we start to then to have a mental model that goes on to say, okay, well, how can those people be impacted? What are the specific issues? And we see that kind of a model coming through now in the new environmental and social framework that the Carbon Disclosure Standards Board developed before they merged into the IFRS Foundation recently. We expect to see that in the reporting standards from the EU, so that we really are talking about this in the same ways and thinking about it in the same ways. And then the second point, briefly, is about better ways of measuring, and the long been calls for there to be less indicators and metrics across ESG, quite honestly, because of the enormous numbers that are out there and the variation. And that's absolutely fair enough. I think the problem is that many have assumed that the task is then to pluck a few indicators from what currently prevails in this space. Whereas in actual fact, what we see is that what currently prevails, not exclusively, but to a great extent, actually offers very little insight into the effectiveness of corporate practices in managing S issues. We actually need better as well as less indicators and metrics. Just by way of example, it's important for a company to have a human rights policy, to do training with the relevant staff, but neither of those points of information is particularly indicative of which companies are really doing the work and succeeding in reducing impacts on people on the ground. A classic example is we know that metrics such as how many grievances have you received can have the perverse consequence of leading to incentives to actually suppress or relabel grievances to have better metrics, better to report out, when the opposite is what we want to happen, people to feel confident to bring issues to the company. So we really need to do better, and I think we can. We and others have been collaborating over a few years now to really look at indicators that tell us more about, how is this company thinking? How is it wired in ways that predispose it to find and address human rights risks, or to miss them, or address them, mismanage them, perhaps one might say. And what are the outcome indicators as well that can really tell a story, whilst allowing that context is really very different where these issues arise for different companies. So there's a lot more to be done. We ourselves are going to be doing some work in the coming months with Principles for Responsible Investment to look into what it is that investors need in terms of S data. And we really need to put our shoulder to that wheel collectively with others to answer this question, because the time is now.
Thank you. So now I would like to invite our two panelists into the discussion. Please come into the screen. First, Cecilia, Théo came here. I was going to introduce Cecilia first. Here you are. You are the Ambassador for Sustainable Business at the Swedish Ministry of Foreign Affairs. Your areas of responsibility include promoting the Swedish government's policy in this area, representing Sweden in organizations like the UN and OECD. And you're also the chairperson of Swedish National Contact Point, an OECD a service connected to the OECD work on this issue. And you're a representative of the GRI government on the GRI Government Advisory Board. And just as an add-on, the previous post you had was to be ambassador in Peru. A very warm welcome to you, Cecilia. And I would like to start by asking you to give an overview how the Swedish government work with these issues. There are a number of initiatives, a number of ministries involved. It would be good for us to know. Get a short picture.
Thank you so much, Mia, and it's been a pleasure to listen to Caroline and the story, because when I look at how the Swedish government works and how we have worked with these issues, I see that we do have sort of a parallel trajectory to the development of the work that John Ruggie did, because it was already in 2002 that the platform, the government instituted a coordination platform to work with responsible business issues, which was then global responsibility, and appointed a CSR ambassador, which was you, Mia. So in this call, we have the first CSR ambassador and the most recent. So it's been 20 years that Sweden has worked with sort of a central focal point within the government offices, uniquely focused on responsible business conduct issues and sustainable business. So in 2015, Sweden adopted its National Action Plan on Business and Human Rights in accordance with the UN Guiding Principles. And that National Action Plan was then overviewed in 2018, and the findings were incorporated in the document that we have today, which is sort of our roadmap on how we work with sustainable business issues, which is called the Platform for International Sustainable Business. And that platform is sponsored or supported, you can say, by two ministers within the government, the Minister for International Trade because of the international issues, but also the Minister of Industries, because we don't see this as a purely international issues. It is a very national issue as well. So that platform is very clearly formulating the expectations that the government have of Swedish businesses, being nationally or internationally. And that is to respect human rights and work with other sustainability issues such as climate, environment, labor rights, gender equality, anti-corruption, etc. And just to give you two very brief examples on how we work with these issues within the government offices on a national and international level. For example, at national level, there has been a special focus on state-owned enterprises because and the idea is that the state should lead by example, and hence the state-owned enterprises need to work very diligently when it comes to human rights, and there's even a board guide for the boards to work with human rights issues. Internationally, we work a lot with human rights within with the export promotion work, together with our Team Sweden partners, who are Business Sweden, SIDA, and the export finance institutions, for example. And then moving on the landscape today, and Caroline really did talk a lot about what's going on today. We're definitely in the space where we're moving from voluntary to mandatory, and I'm sure we'll get back to that a little bit later in the panel, so I won't go into that now. We're also in a period of intense policy development when it comes to issues such as human rights and digitalization, connected to climate change, connected to corruption, and as Caroline also mentioned, a very, very topical issue right now is how businesses can use leverage or not when it comes to extremely difficult markets where, for example, there are state-sponsored or systemic violations of human rights. I'll stop there, and I'm sure we'll get back to the other issues. Thank you.
Thank you very much. We will do so. And but before doing that, I want to turn to Théo Jaekel. Welcome. You are a legal counsel and business and human rights expert at Ericsson, responsible for embedding the company's human rights commitments and strategy across the value chain. And prior to Ericsson, you headed the human rights practice group at Vinge law firm in Stockholm, advising clients on how to address human rights risks. And you also worked at as a researcher at Swedwatch, conducting research on corporate impacts on human rights in different countries. So, additionally, you also lecture on business and human rights at Stockholm University, and you are a board member of UN Global Compact. Very welcome, Théo. And I also wanted to give you a broad question to start up with, and that is how you work as a company in implementing the UN guiding principles in the organization. Please, Théo.
Thank you, Mia, and thank you for the opportunity to speak today and provide some insights from the corporate perspective on this very important topic and the important developments that we are facing in this space. So Ericsson, of course, we've worked with business and human rights for quite some time. I mean, we were one of the founding companies of the UN Global Compact back in 2000. But of course, the UN guiding principles were very much a game changer for everyone, including Ericsson, in how we address and approach the issue of managing human rights risks across our value chain. So quite early on, after the adoption of the UN guiding principles in 2012, we have since then worked actually quite closely with Shift in embedding and implementing the UN guiding principles across our value chain. This includes, strengthening our processes and the governance structures that we have, but also conducting specific human rights impact assessments, both on country level, but also from the perspective of specific technologies, for example. Giving you one example of how we have embedded this, and which I think is also important when we come back to the discussion on the regulation, is that we look at the processes that we have in place differ a little bit between when we manage and address risks in our supply chain and when we deal with issues related to the end use of our technology and potential misuse of technology. And the reason why we have two separate processes here internally is because of the risks are quite different. And that's also important when you look at it from a UN guiding principles perspective, is that we as a company are expected to identify our salient or prioritized human rights risks, regardless of where in the value chain they might be present or relevant. So when we talk about the supply chain, we primarily deal with risks related to labor issues. So issues such as forced labor, overtime, living wage, occupational health and safety, those types of issues are our prioritized risks in the supply chain. While when we deal with the end use of our product, it's mainly risks and impacts related to right to privacy and freedom of expression, for example. And it is important for us to distinguish between these two sets of risks, because that is also going to inform us how we design our due diligence measures and what type of mitigations we put in place. So again, it's not this one size fits all model where we just have a one approach where we deal with the issues regardless of what type of risks there are. But it's also important to really stress the value chain perspective. Our risks are not just present in the supply chain or in the first tier of a supply chain. It's really both in our own operations, our supply chain, and the end use of the products. And just to go back to the implementation of the UN Guiding Principles again, I think this is when the UN Guiding Principles were developed, there were also parallel processes specifically looking at how to address this from the perspective of the tech industry. We're also a member of an organization called the Global Network Initiative, which was established during the same time, which uses the methodology of the UN Guiding Principles and applies those principles specifically to the tech sector and deals with issues of privacy and freedom of expression. And I think that goes back to the point that both Caroline and Cecilia raised with this smart mix of measures, is that we have the framework of the UN Guiding Principles that then needs to be adapted to specific circumstances, specific industries, and businesses. So we, of course, are also very much looking forward to the regulatory developments and how this can further strengthen our work on business and human rights, and really grounding that debate and the regulatory drafting in the methodology of the UN Guiding Principles. Thanks.
Thank you, Théo. Before I give the floor to, or if we have a question, I just wanted to ask you, coming back to what we're expecting tomorrow, which is that the European Commission proposal for mandatory human rights and environmental due diligence is going to come on the table. And some observers say that this could be a game-changing moment, going from, as you said, Cecilia, one example of going from voluntary to mandatory for corporate accountability. And as an example, it's going to include public and private enforcement provisions. What is your thinking around that? Is this a game changer? Will it actually, as you say, and ask for, and we all ask for, change what the situation for people on the ground, or will it take a long time? Of course, it has to come in practice first. But what is your view? I start with you, Caroline.
Sure, thank you, Cecilia. It should be something of a game changer, but as I reflected, it depends a lot on how nuanced and careful it is in its attention to alignment with the guiding principles, to thinking beyond just the words on paper, to what it takes to implement and enforce that, both implement by companies and enforced by governments, and getting all of those pieces right, finding the right place and scope for civil liability. Those are, I think, questions that we'll be looking at very, very closely. It is important, and this is something we'll certainly be paying attention to, that in line with the guiding principles, it is about the full scope of the value chain. We know there are different things that companies can do at different points in the value chain, but back to Théo's point, the critical issues and risks don't necessarily arise in your first tier alone. They can be deeper upstream or downstream, and all of that needs to be in scope, even if it's not necessarily connected then with civil liability in those more remote relationships. We're going to need to see something about meaningful engagement with affected stakeholders. That's going to be critical to whether this really makes that kind of behavioral change, set different assumptions about what it means to understand and address these issues in practice, and that focus on the severity of impact, those salient issues, and how companies can be using their leverage to affect outcomes. So there's a lot there that's going to depend on the specifics, we'll certainly be looking at those issues. I'd simply say finally that it should be a game changer in many regards, but back to that point, it's not a silver bullet. No legislation can do the work that needs to be done in this arena of business and human rights. No piece of legislation can do that alone. We need all of these other forces alongside and aligned and coherent and sending the same incentives and messages. So it's part of a bigger puzzle.
Thank you, Cecilia. Just to add on here, what are the next steps when it comes to this this proposal that we hopefully that we have been waiting for some time, which will come tomorrow, and having the presidency next in a year's time or the beginning of the first half year next year? Will this issue be on the table? Will that be an important part of the of your work from the government?
Well, yes, I think absolutely. We are right now entering into the so-called EU presidency trio, because right now, of course, we have the French presidency followed by the Czech presidency and then the Swedish presidency in the EU. And we know that our colleagues in France are very eager to get this get the ball rolling and start the dialogue within, or the discussion within the EU on the proposal that's coming up tomorrow. So we are expecting quite a tough schedule in the following months when it comes to negotiations and discussions. So, and I think from the government view, we don't really know. We haven't seen the proposal yet when it comes to due diligence. So exactly how it's going to work is going to be tomorrow's news. Yeah, no, we will definitely be working with this in the next month, and probably also during the Swedish presidency.
Okay, Théo, you were one of the signers of signing companies of an initiative in the beginning of February asking for this that's coming tomorrow. Can you kind of give some sort of background what was in that statement, the joint statement that you and I think about 100 other actors put forward in order to ask for this this proposal to come forward?
Sure. So this statement that was published just a few weeks ago was actually a follow-up to an earlier statement that Ericsson and many other companies were part of early on in the process already a few years back in support of this type of legislation. And we've already heard, of course, many of the reasons and the arguments in support of this. And one is, of course, the harmonization. I mean, Caroline's introduction here already presented the wide range of different types of regulations and legislations that are out there, both on regional, national level. And while, of course, it's good that we see a development towards more stricter or clearer regulation, there is also a challenge for companies that this creates a patchwork of measures. So doing this on the EU level hopefully will create a harmonized and level playing field. So that's one part of why we've pushed for this, is to do it on the EU level to ensure that there is a common approach for companies within the internal market, but also companies operating on the internal market. The other issue is also, I mean, with the level playing field, is that the current status quo, where we know that most companies are not taking their responsibility seriously. I mean, there have been done studies both on the EU level and in certain EU member states, including Germany, that clearly conclude that most companies don't implement human rights due diligence measures. And the current status quo creates then an imbalance towards those companies who actually want to do this seriously and take the responsibility. The responsibility is then shifted to those companies rather than, again, creating this level playing field. So there are, of course, a few in this letter that we outline, a few issues that need to be addressed. We've already talked about the full value chain approach. In order to avoid this tick box exercise, we shouldn't focus on simply just the first tier supply chain level, because that might not be relevant for all companies. So that will just create a kind of administrative tick box and not actually creating better outcomes for people. The stakeholder engagement part is also, of course, crucial. I mean, that's a part of an effective due diligence. Human rights due diligence without stakeholder engagement is like customer satisfactory surveys without talking to customers. I mean, it doesn't make sense. So we really need to implement that in the legislation as well. And then we acknowledge, of course, that any effective legislation would need some kind of sanctions, if it's civil liability or enforcement mechanisms. There are, of course, challenges in translating the UN guiding principles to a regulatory standard and having civil liability. But without civil liability, there isn't going to be much teeth behind the legislation. So I think that's also an important factor.
Thank you. Do we have a question?
Yes.
Please, Julia.
We have two questions. One that I think could be to Caroline, and that is, can you comment on the upcoming regulation in terms of human rights? And also the other one is to Théo. Can we get a comment from Théo on the latest corruption scandal, which especially what steps are you now taking to address this?
So shall we start with Caroline?
Sure, and just seeing it in the chat box, it seems particularly to look at the Uyghur Forced Labour Prevention Act, which is a US act, of course, looking at the situation in Western China, and it ties into what I was commenting on about the quite distinct approach in the US around the Customs and Border Patrol, right? What this act is sort of saying is there's now a so-called rebuttable presumption that goods that are made in part or in whole in Xinjiang region are tainted with forced labor, unless, right, the way to rebut that presumption is to show evidence that they are not, and that ties into the ability of Customs and Border Patrol to withhold goods until such evidence is forthcoming. And as I noted, both in Canada and there's already moves in Canada that are implementing similar approaches, and even some mooted discussion in the European Union context around this kind of withholding of imports. It is a really interesting model, and one that bears study in terms of, if I can put it that way, focusing minds, because when goods are withheld at borders, it is highly disruptive to companies. And we have seen in the US application of this, I think it's in the context of Malaysian rubber gloves, actually, and forced labor allegations in the manufacture of rubber gloves in Malaysia, that it has led through the withholding of goods to something in the order of $150 million worth of reimbursements to workers who were charged fees as part of being caught in a forced labor cycle. So it is seen to have teeth, and it is seen to be effective. These are interesting and distinct models. I think what we need, whatever models are adopted in whatever countries, is that they are still speaking to those same underlying principles that, you should know where your goods are coming from, know how they are made, be taking measures to address the risks that sit there, and certainly not waiting until they arrive at your borders before doing so. And that's an interesting model for pushing that approach as well.
So the second question, was for you, Théo.
Sure. So, I mean, of course, the recent statement that we put out about what happened in Iraq is very concerning and very severe. At this stage, I will, however, not be able to go into any further details than what is in the public statement. So unfortunately, I can't really comment on that. But if there are any other questions, I would refer you to our media department for those questions.
Okay, thank you. I was wondering, I mean, we are talking about maybe a game shift here, and also the need for a lot of activities in many areas and in many in companies, in governments, etc. When it comes to competencies, if we do get this new legislation in place on the EU level, but also see other types of legislation come around also in other corners of the world, what of what are the needs in terms of competences in companies, but also in other areas, like in the government agencies. Is it a problem, or I know you, Caroline, you're advising a large amount of companies and the Commission and governments, etc. Do we have enough of expertise in this area? Can I start with you, Caroline?
Sure. Look, I think for most national enforcement agencies, this is relatively new terrain. So quite naturally, there's going to need to be a ramping up of competency and capability there in order to provide for effective enforcement. We've been doing some work with the Office of the High Commissioner for Human Rights to set out some of the issues that we think are going to need to be part of that mix, and making sure that organizations are prepared, including, and I go back to something I said earlier, and Théo referred also to this sort of avoiding the tick box compliance approach, right? We must not miss the mark with this. It's really important to the companies that are doing the serious work, and to creating the incentives for the companies that aren't yet doing the serious work, that enforcement agencies can tell the difference. We often talk about this in terms of signals of seriousness. What is it that you want to look at that isn't just, we have a human rights policy, we trained people on human rights, that really tells you something about whether this is a company that is grappling seriously with the issues. And we must also not fall into the trap of thinking that this is about a company never facing any challenges, risks, or incidents, right? This is a highly complex terrain, and things will happen, but you can still clearly, I think, find ways to distinguish, and for national enforcement agencies to find the capabilities to distinguish between those that are really going about it the right way and more likely to be ahead of the issues and dealing with them well, and those that aren't.
So how about government and the agencies that will be involved in this, given if we get a new legislation in place? What do you say, Cecilia? What do you see?
Well, I think I can just echo Caroline that yes, there is definitely a need to strengthen the competence in many national authorities, agencies, and even within government. As it is today, we do have some agencies who are working with similar issues. For example, the conflict minerals regulation does have due diligence, is a due diligence regulation. So we do have some agencies who are working with this. I think the corporate sustainability reporting directive will also mean that we will have other government agencies who will start working and on these issues a bit beforehand. When it comes to human rights due diligence, however, I think on the upside, there is a wealth of information out there. There is so much information on how to do it, how it works, sharing of experiences, best practices. So it's just it's actually just an issue of getting started. I can say we've already started a little bit within the Ministry for Foreign Affairs. We held we're holding internal webinars for our colleagues out at the embassies, together with the Raoul Wallenberg Institute and our Team Sweden members, to raise the awareness in our own organization on the issue when it comes to business and human rights. We're also, for example, right now translating the OECD due diligence guidance to Swedish to make it more accessible for Swedish companies to see what is due diligence, how do you work with it. So yes, there is definitely work to be done.
And Théo, what about, I mean, your own company, yes, but also how do you see it in general in the business sector?
So I think one area that we are working a lot with, and especially in the tech sector, but I think this rings true for all sectors, is to move away from maybe practices where we've been working very much in silos between different companies. So when we do a human rights impact assessment, for example, it's just our company, and then a separate company does their own human rights impact assessment and so on. And within the tech sector, we are now very much talking about an ecosystem approach. So how do we make sure that we identify all actors in this ecosystem, not just companies, it can also be governments, other stakeholders, and how can we have joint approaches in both identifying and addressing risks specific to for example, the tech sector. And we are doing this work together with the Office of the Human Rights Commission at the UN, or Commissioner in the UN, within the Global Network Initiative and several other stakeholders. And I think this is really the kind of next steps that are needed, is to move from single company approaches to more collaborative and ecosystem approaches.
So that will be the last word, and I think that's a good word also for the future and how one has to work with this issue. And I thank you, all of you, very much. I thank the audience for being part of this, and I know we're going to get back to these issues as they are evolving the coming year. And just going back to where we started, for those who want to learn more about the process behind the development of the guiding principles, I recommend John Ruggie's book, Just Business, Multinational Corporations and Human Rights. Citing Anne-Marie Slaughter, Professor of Politics and International Affairs at Princeton University, the book recounts the story of one of the most effective human rights initiatives undertaken in recent memory in a way that makes it essential reading for activists, scholars, students, policy experts, and business leaders alike. So, SNS Sustainability Talks will continue to come back with important topics later in the spring, and I hope to see you there again. Goodbye.